My name is Eloise Scotford. I am a Professor of Environmental Law at UCL and I'm the Dean of the Faculty, and it's my absolute pleasure to welcome you this evening for this, by the number of people that have turned up, important and timely event. This is the third in this series that we've done with Green Alliance and UKLA and the UCL Centre for Law and Environment, where we have looked at the tectonic kind of shifts that have happened in environmental law in the UK over the last 5 or so years. We did the first one as we were making sense of what Brexit had done to, or might do, would do for environmental law in the United Kingdom, looking at the challenges, the changes, the gaps, and that was a really important. Event. The second one, we were trying to remember the years of all of these. I think that was 2019, and then we did another one. We think in either 22 or 23, when the Rule Act was going through Parliament, where it was kind of the new dawn of the Environment Act as well, and we were trying to think about its potential, and it felt a bit all potential at that point, but we had lots of questions. And then we come again together as a community, and that's why it's so wonderful to see so many people from all walks of environmental law life here this evening, to think about where we are now with a new government, with shifting geopolitics, with persistent environmental issues, with a confident OEP doing lots of fantastic work, to ask where are we now and where are we heading at this point, and what do we make of it all. So, my job tonight is to welcome you and to chair this evening's event. I'm going to introduce the speakers on the first panel and then hand over to them. And I think this is the order in which we're doing it. Ruth, in the order in which we're sitting, yes. So first let me introduce Ruth Chambers, who he's not only our first speaker, but has been fundamental to organising the event along with Maria Lee, who will chair, beyond the second panel, speak on the second panel, my colleague at UCL. So Ruth Chambers, thank you for the work supporting and helping create the event, Ruth. She's been working with Green Alliance since 2017 to lead the environment group's work on shaping the post-Brexit legal and policy landscape. And first through the Greener UK Coalition, and now through a dedicated unit on legislation and governance. In addition to the Green Alliance role, she's an honorary professor of practice at UCL and an advisor to River Action UK and the RSPB, chair of the National Charity Feedback, and I can't resist including this element of Ruth's CV, included in the 22, 23 and 24 ends power list of high-impact environment professionals, and has many other accolades. Dame Glenys Stacey will be our second speaker, a solicitor by profession. She has a wealth of CEO and regulatory experience, having led the startup and development of a number of public sector organisations responsible for legal or regulatory services, and tonight is here particularly because of her role in the setting up and first chairing of the OEP. An interesting thing from your CV, Dame Glenys, is your chairing of the Independent Review of Farm Regulation, which has become particularly relevant, I think, to your work in the OEP, which you did at the request of DEFRA at the time in 2019. Then we have Rosie Sutherland, who is RSPB's Head of Environmental Law. RSPB is the UK's largest nature conservation charity, and I think having that perspective from an NGO is a really valuable thing to have on this panel. And then Professor Chris Hilson, last but not least, who is a very esteemed environmental law academic in the UK, has been at the University of Reading since 1996, and before that, interesting nugget from your CV, is before that was an advisor, a policy advisor to the waste industry, working at the Environmental Services Association, which I actually didn't know about. But in his academic role, editor-in-chief of the Journal of Environmental Law from 2008 to 2012, has advised various NGOs, has an extensive body of academic work on UK, EU and comparative environmental law, particularly climate law and law and social movements, and is certainly one of the most respected environmental law academics in the country. So wonderful to have you as well, Chris. I am now going to hand over to our speakers who are going to speak on the topic of legislating for environmental governance across the UK. They're each going to make their short contributions and then we will open up to questions. So, Ruth.
Hi everyone, thanks for coming. Can you hear me okay? Yeah. Fantastic. I'm the warm-up act, and I really hope I can warm you up in the lecture theatre in more ways than one. And I'm going to put a question to us that I'd like us to think about together as I speak. And that question is, 5 years on, did we get a green Brexit? A very good question, and I'd like you to be the jury for the evening. We're a very kind of legally qualified audience in many ways, so I want you to share this conversation with me. But first, I want to cast our minds back to 2017, when Government Minister and Brexit architect Michael Gove said the following: leaving the EU gives us a once-in-a-lifetime opportunity to reform how we manage agriculture and fisheries, and therefore how we care for our land, our rivers and our seas. And we can recast our ambition for our country's environment and the planet. So race to the top beckoned. We would go faster. We would do better than the EU. So what happened? Well, first, let me present the case for a green Brexit, which I would argue has 4 main parts. The first of these, you've guessed it, is about farming. The first really that anyone thinks of when we're thinking, did we get a green Brexit? And it's the commitment of successive governments, not just the last government, to focus farm payments on restoring nature rather than just rewards for the size of the land farmed. And breaking the binds of the common agricultural policy, which we were able to do when we left the EU, is a very good thing. Although there are questions about the pace of that agricultural transition as we cast anxious looks at the forthcoming spending review. The second point in favour of Green Brexit is that there are now strong legal frameworks in place across most of the UK to keep future governments in check. When we first identified the governance gap that would be created by the UK leaving the EU that Eloise just mentioned, the government's initial response was that the replacement did not need to have a statutory footing. Luckily, thanks to the efforts of many people tuning in and in the room, including parliamentarians, civil servants and campaigners, we persuaded all of the governments of the UK that each country needed a new national governance system and that this should be grounded in law. More on progress on these in a few minutes from Rosie Sutherland. Number 3, and this is only in a handful of cases, we in the UK have chosen to move faster than the EU. And the most obvious example of that was when we won the race to put net zero into law. We were the first country to do that. And then fourthly and finally, and this is all credit to the UK government and the Scottish government, for standing firm on an important test case, which is going to be before the Permanent Court of Arbitration next week in The Hague. It's about sand eels, in case you weren't following that really important story. And it's going to be a test case of the UK and EU's trade and cooperation agreement. This is really important for marine conservation because sand eels feed puffins and many other loved seabirds. So that's the case for a green Brexit. Now I'm going to turn briefly to the case against a green Brexit. And again, for the sake of fairness and balance, I'm going to present 4 main elements, although you may argue that we could add to that list. First of all, I'm going to start with chemical safety. Before Brexit, the UK was a member and helped to set up something called EU REACH, which is the world's gold standard system for regulating chemicals. But when we left the EU, we had to leave that system. And since then, sadly, we've fallen far behind the EU's programme of restricting the use of hazardous chemicals. If you've been reading The Guardian recently, you'll see a horrifying series of articles about forever chemicals, known as PFAS, which are polluting our drinking water, our wildlife, our farmland, and also accumulating in our bodies. And thanks to a group called Watershed Investigations for bringing that to our attention. The second part is that, unfortunately, the case that important protections have been attacked, undermined, and in some cases removed is true. For some, Brexit was an opportunity to strip back regulations in the name of sovereignty. In the last 5 years, we've seen an outright attack on nature and the bodies that seek to protect it, principally Natural England. The last government sought to undermine water pollution rules known as nutrient neutrality, a ploy that was rejected, fortunately, by Parliament. And thanks to a Herculean effort, the last government was prevented from sacrificing thousands of environmental protections by accident or by design in the retained EU Law Act that Eloise mentioned the last event was about. Now, while the new government has so far shown little inclination to parrot that Brexit ideology that drove the retained EU Law Act, it has unfortunately gripped some of the rhetoric of its predecessors, for example, by promising to bulldoze planning. This does not bode well, but hopefully DEFRA Director Becky Shrubsole can allay our fears in the second panel. Thirdly, governments have displayed an aversion to what we call non-regression. There have been many, many warm words from ministers that standards will not be diminished by Brexit. In fact, they'll be enhanced. But they've had a reluctance to put that commitment into law. Ministers had the chance to do that in the Environment Act and in the retained EU Law Act, but they chose not to do that. Interestingly, a bill currently passing through Parliament on product regulation does suggest that the current government may be better disposed to aligning with EU standards because it wants to give itself the power to do that under certain conditions. The final potential nail in a green Brexit's coffin, what is it? Well, it's dither and delay. And these, they sound quite innocuous terms, but they've held back progress, including on measures which the EU is progressing, such as tackling deforestation, but also on other welcome domestic fronts, such as ending the digging up of peat bogs for garden compost, outlawing the use of toxic lead in ammunition for outdoor shooting, redirecting fines from water company pollution incidents to nature recovery, introducing a deposit return scheme, which eventually did pass through Parliament yesterday evening, although that was some 9.5 years after it was first proposed by Michael Gove. They're just a few examples. Well, dear jury, as you gather your thoughts on whether Brexit was indeed green or another colour of your choice, you may like to reflect on some of the choices before the current government. I'll start with the government's Environmental Improvement Plan, which Dame Glenys will shortly speak about. The new government has promised to make this fit for purpose, and one of its first moves after the election was to launch a rapid review of the plan, which was welcome. When the new plan is published later this year, we'll know if it will be better than its predecessors. And while the signs are encouraging, we really do need to see a much better product. Perhaps a more reluctant candidate for government action is when we will bring ourselves back into compliance with the Aarhus Convention. This important agreement, I'm sure everyone's well aware of it, but it protects our rights as citizens to access environmental justice, amongst other things. It's become tainted by what I would describe as a long-standing disrespect. The new Attorney General has recommitted the government to respect the rule of law, which is good news, shouldn't have to be recommitted, but nevertheless it's welcome. There would be no better place to demonstrate this than on Aarhus. Finally, also very much on the government's to-do list is planning reform, which we'll hear a lot more about in the second panel. Now, the spirit in which the new government is approaching this and its aim for win-wins for nature and for house building is very welcome. The context for this discussion, however, is not free of concern. There have been sustained attacks on legal processes, such as judicial review, and there is a degree of uncertainty about some of the new systems, such as the replacement for environmental impact assessments. More significantly, perhaps, the explicit absence of nature and the environment from the government's missions creates a sense of deprioritisation, even if that is not the intent. And the detail of reforms really matters. If the poet Yeats were to comment at this point, he might encourage the government to tread softly because you tread on the laws that protect our most precious habitats and species. So that concludes the case for and against a green Brexit. My verdict, the dream of green Brexit ultimately has not yet been realised because certain protections and standards have been either subtly or significantly weakened, which has hampered efforts to improve the environment and public health. But there is hope. As our new governance systems bed down and evolve, they've brought greater proximity and, I would argue, a heightened sense amongst us all of responsibility for environmental law. They are being used and appreciated, and there are encouraging signs of them prompting rethinks and sparking citizen action. A green Brexit is therefore in our hands. Thanks, Eloise.
Well, good evening, everybody. My name's Dame Glennis, as you know, and I'm the chair of the OEP. I'm not here on my own, as it happens. I can see our General Counsel in the front row, Peter, and one of our favourite board members, Richard, there as well. So I'm now going to get wired up.
Sorry. There we go.
Is that better? Yeah. Lovely. I don't have to shout, but that's great. So I'm going to take a slightly different perspective now and just spend 8 or 10 minutes talking about where we are in relation to the environment. And that is looking particularly at a report that we published just last week, which is our annual stock take, if you like, of the environment and how it stands. Now, since we last did this a year ago, of course, there's been a change in government. But what hasn't changed are those legal obligations, the established statutory targets and commitments. They are statutory and they are enduring. Now, the headline from this latest assessment, which runs for the 12 months up to March 2024, remains that the government is still off track to achieve its environmental goals and targets. And while there are some areas of improvement which we highlight, we actually found less progress in this assessment period than in the year before. So there's been a regrettable, let's call it lack of momentum. But the challenge is therefore quite significant, isn't it? But it's not, as it's been said, it's not insurmountable. The trajectory we're on can be changed, that's for certain. But the window of opportunity to do that is closing fast. Many of you will know that some of the key targets are very close now. So unless things change, those such as the 30 by 30 at land and sea will not be met. There are also the Water Framework Directive targets due in 2027, and we reported at length on that, and the poor prospects of achieving them we reported last year. And then there's the EIP interim targets, fast approaching in 2028, and air emission targets in 2029 and 2030. So as I say, they are fast upon us and fast upon government. Here is the overall picture in relation to our findings this year. So our assessment is quite comprehensive. If you look at the columns, we're looking at past trends, we're looking at progress within the 12-month reporting period, and we are assessing the overall prospects of whether government is likely to meet its targets and commitments, whether they're on track. So taking that precious forward view. And we show these against the 10 goal areas of the EIP, you know, goals 1 to 10, which I hope at least some of us are deeply familiar with. So what have we seen? The overall picture is off track in large part, some progress, but substantial challenges remain. It sounds like a rather dismal school report, doesn't it, actually, when I say it like that? But let's have a look at recent progress then towards targets and commitments. So this is within the reporting year. So we looked at whether policies and actions are comprehensive, that is, they cover the most important issues, whether they're credible, their development and delivery are high quality, and whether they're coherent, you know, that they work well together, if you like, to achieve the intended impacts. And we assess progress to meeting 43 individual targets and commitments, including the Environment Act targets, as well as the overall progress in each EIP goal area. Now, areas where good progress has been made mainly relate to tackling specific sources of water pollution, phosphorus loadings and the metal mines issue, and then some chemical pollution, PCBs, particularly in mercury. That's not to say that things are all hunky-dory in the world of chemicals and regulation, they're not. And also some progress on greenhouse gases as well. In relation to the natural environment, while progress on ELM schemes continued, and we know how critical they are, progress was more limited across wider actions and policies essential to nature recovery, most notably in the freshwater and marine environments. Please let us give marine its proper place. At the moment it's in the neglected corner, isn't it? Now, there was also limited progress in relation to the patterns of production and consumption, including improving resource productivity, eliminating avoidable waste, and more sustainable use of natural resources. And in relation to human health and well-being, the last one, we've made a bit of progress there in our assessment of it and found there was limited progress regarding air pollutants and reducing the risk from exposure to high temperature. So I wouldn't call that necessarily a happy picture. Let's have a look at the environment targets themselves, the Environment Act targets. They're a special focus, those 13 targets. Good progress has been made towards 3, that's phosphorus loading, metal mines, and the potable water demand. Mixed progress towards 9, and limited progress towards 1, that's residual waste. So if we look overall at recent progress at EIP goal level, the 10 goals, in 5 goal areas progress has been mixed, and in 5 goal areas it's been limited. And compared with last year, our ratings are downgraded for the goals of clean air and maximising our resources and minimising our waste. So you begin to see that this annual assessment is not as daft as it appears. You can make these comparisons and you can build that picture up over time. But let's have a look now at future prospects. Are we in line to meet any of these targets? Well, this year we've assessed the prospects against those 43 individual targets and commitments. Areas that are largely on track relate to specific air pollutants, PM2.5, for example, specific sources of water pollution, such as phosphorus loadings from wastewater, chemical pollution such as land-based emissions of mercury and specific greenhouse gases. And the same areas where recent progress has also been good, if you like, so that, we're looking as though we're getting somewhere there. Now, in relation to the natural environment, such a pressing issue, while the prospects of achieving nature-friendly farming commitments are partially on track, prospects relating to wider actions and policies essential to wider nature's recovery are largely off track, and that's really to do with something already mentioned, which is the continued delays and the lack of urgency when it comes to the implementation of important actions, especially, again, in the freshwater and marine environments. And then sustainable soil management remains an unhappy cousin, a significant gap. So the prospects of meeting targets and commitments in relation to patterns of production and consumption are largely off track, and there's no excuse for that. And in relation to human health and well-being, while the prospects of meeting the 2 EA21 targets for PM2 are largely on track, the same cannot be said for the range of other air pollutants. And then there's a persistent lack of progress in reducing exposure and vulnerability to climate change risks. It seems remarkable, doesn't it? But that's the case. And we really do need to see an increase in the scale and pace of adaptation actions to improve the prospects of meeting targets and commitments across many EIP goal areas. You'll see the connection between climate change and everything else that we're trying to achieve. So what are the future prospects then of meeting environmental Act targets, those 13 targets? I could run a bit of a betting shop here to see what you might come up with, but because I'm against time, I'll go straight to it. The government is largely on track for meeting 3 out of the 13, partially on track for 4, and largely off track for 5. And of those 5, I'd mention particularly agricultural water pollution, so significant. And then the prospect of meeting just one of them, actually, we're still not yet able to assess. So, what are the overall future prospects then? So, at EIP goal level, we're not on track in any of those 10 goal areas. In 3 goal areas, we're partially on track. In 7, we're largely off track. So, compared with last year, our assessment ratings haven't changed, but we've now been able to assess that last goal of enhancing beauty, heritage and engagement, which we assess as partially on track. So, let's have a look just quickly now. I've almost finished, but what is holding back this progress that we so much want to see? We know that prospects aren't fixed. In our last report, we identified factors impeding progress and prospects. They include, as I've said, delays in key policies, strategies and regulatory frameworks. And this is particularly relevant in those areas where we've seen less progress last year than we saw in the year before. Those delays are particularly apparent. And for example, I'd mentioned the continued delays to waste collection and packaging reforms. And then actions don't address all major pressures. Again, I highlight that when it comes to, for example, clean water. There is a need to give diffuse agriculture pollution and physical modifications the same attention as sewage pollution, and that's been apparent for a good number of years now. Now, question for you as you think about whether all of this requires legislative change, because we argue that in many cases there are well-established solutions and tools and actions, and they're well understood in the main, actually. There's a lot there on the stocks that could be done, but resources are not given at the level needed. So we continue to see that across goal areas. Efforts are too thin by far, and a lack of urgency with which positive actions are implemented, as though we have all the time in the world. And again, this occurred across our goal areas, or the range of goal areas. So those 4 factors, if you like, we find apply just as much this year as last. So government's got these legally binding commitments. A lot of them are only 5 years away. There's to be a revised environmental improvement plan to be published later this year. It will cover the whole period really up to 2030 and beyond, so 25-year plan. It will be a critical plan in our view. It will be the nation's plan for the environment, the plan that this government owns, the plan that this government must deliver, and the plan that this government must resource. It couldn't be more significant in our view, and we wait with bated breath for it. Now, we make 8 recommendations for action and key enablers that build on our advice to government. We've already given advice to government on what a good EIP looks like, and we've given advice to government on what we'd like to see in this revised EIP. So let's see what comes out. It does need to focus, of course, on government's environmental priorities and those 10 goals, but also it needs to show how we're going to meet those legally binding targets. Let me end by just looking quickly at these recommendations, and then I'll finish. So first 4, get nature-friendly farming right. So we've all seen tractors parading through London, Oxford and elsewhere. And of course that does suggest to us that relationships are at a pretty low ebb. But those farmers that are driving those tractors need to drive change, don't they? And they need to drive change in the field. A lot is riding now on those agri-environmental schemes. They're promising, actually, and take-up is, starting to get better. But we need greater uptake of the most environmentally ambitious schemes, actually, the countryside stewardship and landscape recovery schemes. We'll be watching that take up closely at the OEP, and we need more spatial targeting, if you like, as well, to make sure the right things are happening in the right place so that they deliver for nature on land. And of course, it doesn't do much, actually, still, for our rivers and lakes. So, it's not the answer to everything, but there's a lot of eggs in that basket. We want to maximise the contribution of protected sites for nature. The current frame isn't working well enough, and we need more effort put into to policing them, to improving them, and to actually designating sites as well. really a classic case of underinvestment here that could be readily sort of corrected. Speed up action in the marine environment. You know, we are, I think just a couple of weeks ago, launched an investigation to see whether DEFRA had failed to meet the legal requirement of marine good environmental status. That target, an apex target, was due to be met when? 2020. It's now 2025. Doesn't mean that target isn't absolutely relevant. So we do need a new UK marine strategy that focuses action on those descriptors not yet at good environmental status, and we need to maximise progress here because that delay looks remarkably like neglect, which could actually be extremely difficult to recover from if we don't act now quickly. And then clear mechanisms for reconciling competing demands. Now, this is all about the land use framework. I think it's imminent. Maybe next month, we'll see. It might brighten up a dull February. I am really hoping that it is a solid piece of work, not some high-level principles, and that it has some detailed analysis and content that will help decision makers in the field to balance conflicting demands well enough. Just 4 more recommendations and I'll stop. Circular economy, I've said enough about waste probably, but we do need that resource and waste strategy updated, and we need a framework for a circular economy. We need to mobilise investment at the scale needed. So that's really about government thinking about how to get the money in. You know, the classic tools are there. You know, incentivise, provide good oversight and effective regulation, create market confidence and get on with it. I mentioned regulating more effectively. Regulation, you know, I have been round the block a few times as a regulator. I love regulation. It makes me happy. But it doesn't always work. And you've really got to work very hard as a regulator with enough hindsight, clear sight and foresight to regulate for the issue you're trying to deal with and to regulate in ways that will make people who are doing things you don't like do the things you actually like. It requires effort, and we just need to get better at it. And then harness the support needed to achieve these actions. So government needs to provide clear leadership at the highest level, and it needs the wider stakeholder environment to be bought in and able to play their part and actually know what their part is. And a first step would be to get that new IP much more transparent and better communicated so we can see what we're trying to do. So I'll just conclude now. For me, that new environmental improvement plan is absolutely key. I feel like I'm waiting for a baby to be born. It's so critical. It will be the nation's plan for the environment, and we desperately hope it's a good one and that our advice has been followed. Our recommendations in our latest report are designed to look ahead, to think how any government can get to achieve its ambitions and goals for the environment. And we hope it's particularly timely and helpful to this government as it does consider a new EIP. So we wait and watch for that. So much is riding on it, and we will be scrutinising it most carefully when we have it in our hands. Thank you very much. Thank you very much for listening.
For those of you who are standing room only, there's a couple of seats down the front.
Thank you. Thank you. Does that work? Can you hear me? Fantastic. Well, as Ruth said, thank you all very, very much for coming along today. Just to be clear, this is very much going to be a whistle-stop tour. Most of you in this room and watching online will be well aware of our current governance arrangements. But for anyone who isn't, I would encourage you to make sure that you have a look at the governance body's strategies, their enforcement policies, and also all the websites have a lot of the previous reports and work. So do have a look. There's been some incredible work done already. I should add the photos aren't significant. I just didn't have any fancy graphics, so I thought I'd add some photos. So what we have currently, well, they're sort of significant. So as you all know, we've just heard from Dame Glenys, which has been brilliant. We have the Office for Environmental Protection,
for England and Northern Ireland, and also reserved matters. I have to be honest, I'm still not entirely clear all that that may cover, but I know there will be people who are. We have Environmental Standards Scotland, and we have the interim assessor, environmental protection assessor for Wales, and I'll just quickly run through each of them. Again, many of you will be very, very familiar. So one of the great things about the OEP is within the Environment Act that created it, 2021, it has a statutory principal objective, as you can see on the slide, which I think is incredibly helpful. Key functions, again, just to whiz through this, it's the scrutinising and the reporting specifically on the environmental improvement plans, targets, and also those interim targets, crucial interim targets that we've just been hearing about. There's also a very helpful wide scrutiny of the implementation of environmental law, where it can turn its hand at anywhere that is perceived to have issues. And its implementation, but also that actual practical on the ground application. And then also the enforcement, again, through its own initiative, starting its own investigations, but also through a very welcome procedure where the public can write in and submit complaints. And again, there's a range of enforcement powers, which I won't go into just now. Also, there is advice to government. And I just wanted to specifically mention the interventions in key environmental law cases, the judicial reviews. Again, I think this is incredibly helpful that they have the ability to do that and that they are doing so. So, Environmental Standards Scotland. So it's the UK withdrawal from the EU Continuity Scotland Act, 2021, known as the Continuity Act for short, obviously. Again, very, very similar functions. I'm going to come on a bit later to the differences between these two specific bodies, but just to whiz through them. So monitor compliance application effectiveness, can produce an environmental improvement report, and as with the OEP as well, when that is published, there is a responsibility for responses to be received. It also is able to investigate and has its own enforcement powers, and again, has this very welcomed ability for NGOs, members of the public, civil society generally, to submit representations to it and give them a heads up or very detailed information about perceived failure to comply with environmental law. The Act, the Continuity Act, is just worth mentioning because I'm going to come on to the differences, as I said. The Act actually includes, the Continuity Act includes a helpful list of further measures that can be taken. And I did think it was incredibly useful that these were specifically set out. So again, keeping stock and keeping an eye on development of international environmental law, quality of data, as we all know the challenges with the information that everybody's working with. Also that seeking of expert advice, which the OEP can do as well. And a very specific requirement or ability to collaborate. And just a little bit more on that. So even though ESS has that legislative measure built into the Continuity Act, I do want to be clear that the OEP has been instrumental in cooperation across ESS and also the interim assessor. And there's been a large number of really helpful meetings, information sharing, and crucially, specific considerations of common issues in each of the 4 countries. So working together on common issues, and I'll just mention the SPA review as a particular one for obvious reasons. The Interim Environmental Protection Assessor for Wales, Dr. Nerys Llewellyn-Jones. So this, as it says in the title, was Wales' interim measures. We all know that there was an interim OEP, there was also an interim ESS for a short period of time. Unfortunately, Wales is still in that interim place. The main function is to oversee the functioning of environmental law, and again, very helpfully, the web pages, please go and have a look, are clear about what that does and does not cover. Again, Dr. Llewellyn-Jones has been helpful in receiving information from the public, NGOs, etc., but actually there are no powers nor a function to investigate and follow that through. I do want to add, though, that despite quite a limited remit, especially when you look at the OEP and ESS, and limited resources, there have been multiple key areas that have been reviewed by Dr. Llewellyn-Jones, and the welcome addition of 2 interim deputy assessors, which is great. So this is really what I'm supposed to be talking about. So again, I'm very conscious of time, so I will be a bit quick. Hopefully most of the information is on the slide, but just to whiz through it. Environmental Standards Scotland is accountable to Scottish Parliament, whereas the OEP is sponsored by DEFRA and DERA. There is also, I would say, quite a stark difference in the way that their independence has been legislatively covered. So welcome Schedule 1, Paragraph 1 of the Continuity Act, which is crystal clear that ESS cannot be controlled or directed by any member of the Scottish Government. Did obviously want to add that the OEP does have in Schedule 1 of the Environment Act, does have, well, the Secretary of State and DERA must, well, the language speaks for itself. I was going to say something else. Must have regard to the need to protect its independence. But unfortunately, there was also quite late in the bill process a new provision put in about how the Secretary of State and DERA can issue guidance. It is limited to enforcement policy, but still, that is a large area of work for the OEP. Again, both have very, very similar excluded matters. And then 2 slightly more significant ones. So the ESS within the legislation has a very specific exclusion when it comes to individual decisions. In a way, this is not completely limiting, because they can gather together a number of very similar decisions or decisions made by the same public authority. And obviously we both want the OEP and the ESS to act strategically due to their limited resources. They simply don't have enough resources to look at individual decisions. But it is interesting that that was specifically built into the Continuity Act. And then the final one, I just wanted to flag. So with OEP complaints, I'm sure, again, everybody knows, but you must go through the public authority's own complaints process first. This, it's fair to say, has been a little problematic and has always been led to delays. And I think I understand the reasoning behind it, but as you can tell, I'm not entirely sure. There are exceptions, which is fantastic, and the OEP has been very clear that in urgent and serious and significant cases, there may be an ability to go straight to them. But it is very clearly there in the legislation, so we will try to comply with it. Sorry. And then just the final one before I do a very quick 4-country update. Again, Environment Act, Schedule 1, Paragraph 10.4, just so you have it. There is quite a long list of things that the OEP cannot delegate. And it does appear quite onerous that the OEP's board has to sign off and agree on quite such a long list. And I'm not entirely sure that that's completely necessary. And again, it was built into the legislation, which was interesting at the time. Very, very quick update, as you can tell, and I'm sure many of you know already, there are some gaps in some of the 4 countries of the UK. So great news is that Wales is making great progress towards an environmental principles governance and biodiversity targets bill. I think it will have a slightly shorter name, we can only hope. And the key area is to create a new governance body, absolutely vital, embed the crucial environmental principles into law, certainly applying to policy, and then create the much needed suite of biodiversity targets. I should add that both for Scotland as well, there are some very welcomed biodiversity policies in both Wales and Scotland, but getting those targets into law, as we all know, is absolutely crucial. And then quickly moving on to Scotland, again, Natural Environment Bill is its current title. I think that's going to remain. May even be starting its parliamentary process late spring, I think was the latest. It could now have slipped to summer after any recess, of course. And again, it's legally binding targets with a framework to monitor, report, and also enforce the achievement or the steps that the government promises to achieve those targets. Just quickly, it will also cover national parks, deer management, and unfortunately, but it was in the Environment Act, the ability to change both environmental impact assessment regulations and also the habitat regulations. Now, we hope that, as with the Environment Act, there is a helpful list of restrictions around that power. We are hearing that it will only be used for good reasons, but it would be incredibly helpful to have a commitment not to regress, etc. And then finally, Northern Ireland, there is great progress being made with a private member's bill, Nature Restoration Bill, which again includes those crucial legally binding biodiversity targets, and we hope some stronger biodiversity duties. And I will leave it there because I can see the timer. Yeah. Thank you very much indeed.
It's very, shall I do it?
Great. Good evening, everyone, and welcome online as well to those watching online. So I want to look at targets in the Environment Act, stepping back a little bit. And I'm channeling Eloise here because Eloise wrote a piece not so long ago which said, as academics working in environmental law, legislation is interesting. And we should be approaching legislation analytically as academics. And so that's what I'm trying to do in this talk this evening. And I want to argue a couple of things, really. One is thinking about how we assess legislation. So that's where the 7 A's that I come up with towards the end of my talk come in, because I think those 7 A's are all elements or principles that we can try and assess this particular piece of legislation with. So that's one element of the argument. The other really big part of the argument that I want you to take away from my talk, if you take anything away from it, is that I'll be using a Christmas tree metaphor, because I did the slides at Christmas. And what I want you to think about is the targets on a Christmas tree. And basically, the argument is that the Environment Act makes you think that all the targets are on the tree. And it gives that impression. Whereas actually, what I want to suggest is that this is more like what the Christmas tree looks like. A lot of targets are in another box, perhaps in the attic somewhere. And the actual tree looks more like that one, which to an environmental lawyer is actually quite a lovely tree. I quite like this one more than the last one. But actually, the baubles or decorations we have on the tree are fairly limited. There's a lot that is still in the box. So that's the kind of key takeaway. The Christmas tree, just to go back to the other one, I mean, there is a phrase for trees, a Christmas tree bill or Christmas tree act, which is basically where government takes an act at bill stage, and then all sorts of people recommend all sorts of amendments to it, and it ends up a complete mess, basically, because it has all sorts of disparate stuff in it that doesn't really belong and cohere in the Act. And the Levelling Up and Regeneration Act was described in that sense. But I'm not using Christmas tree in quite that way. Okay, so the basic idea is that not all of the Christmas decorations are on the tree. Just to think a little bit about the Act itself and what it says, well, it says that the Secretary of State may make regulations, and those regulations basically have to set long-term targets, and I'll focus in on the coloured bits on air quality and biodiversity here. And then we're told that the Secretary of State must make 2 specific additional targets as well, again, on those issues I've highlighted there, just to give a couple of examples there. So, that picks up those same issues in those additional targets. So that's what the Act says. And these are the baubles, if you like. These are the statutory instruments, the regulations that have been introduced under the Act. And these are the ones, using my metaphor, that are hanging on the tree. And the ones I've highlighted in colour there are, the same. I'm just picking out a couple of examples rather than trying to go through them all. So if they're not all on the tree, where are they? Well, this is the Act itself. If you look on, on the government website on Acts, this is how you will view it on the table of contents. You'd think that the targets would all be somewhere in 1 to 7, right? But actually, environmental improvement plans, which we've heard a lot about already today, and we're expecting that government one any minute now, which should come out with a bang and a whiz. That is covered from section 8 onwards. So, if you look at the environmental improvement plan of 2023, you'll see that, there are plenty of targets mentioned in that, as you would expect. Some of those are basically the same restated targets as the ones that were on that list of regulations that I put up a minute ago. So the environmental targets, biodiversity regulations, that's one of the baubles on the tree. That is restated in the Environmental Improvement Act, Plan 23 set of targets. But also in the Environmental Improvement Plan are interim non-binding targets. And so I suppose the point I'm trying to make is that if you look at the Environment Act, yes, there are some shiny targets, but there are some less shiny baubles on the tree which are in the Environmental Improvement Plan. Why are they less shiny? Well, because they're interim targets which are non-binding and they don't have their own set of regulations because they're not binding. Okay. The Environmental Improvement Plan also has some things that are not on the tree at all. That these are targets that already exist and are elsewhere. And I just want to flag one here, which is the Water Framework Directive target, which Dame Glenys was talking about a little bit earlier. It's interesting, if you read the Environmental Improvement Plan, it's not actually described as a target at all. It's described as an objective, and it lacks a date. There is a temporal element in one part in the 25-year Environmental Improvement Plan, which talks about achieving it as soon as practicable. But yeah, it should have been a target in there because there is a 2027 target date, which Dame Glenys mentioned as well. So yeah, that target is one that's in the plan, but it's one that isn't really part of the Environment Act tree at all. Okay, so what else can we say about those targets that are not on the tree? Well, if we look at the significant effects review that the Act contains in Section 7, that requires the Secretary of State to review the targets, basically to work out whether we need any more targets to significantly improve the natural environment in England. And there was a review done, and I put it up there for two reasons, really. First of all, because it sets out that, yes, they've got some new stretching targets. Those are the ones that are on the Christmas tree in the Act already that we've seen. But it says there's already other targets that are not on the Environment Act tree. We've got these existing targets elsewhere. So the review is useful for that point of view. But the other thing you might want to say about the review is it's kind of pointless in a way because it's the government marking its own homework. It's basically said, look, all of our targets are wonderful, they're all doing a proper job, and there's nothing to see here. Well, that's no great surprise, is it? It really should have been given to the OEP, this particular duty, for them to work out whether they agree with the government on that. Okay, so yeah, what other targets are there? There's loads that we could mention. I've just picked out a few on the slides here. And picking out that one that's a kind of thread throughout the talk is the one in the Water Environment Regulations 2017. That contains the key Water Framework Directive to achieve the good status in our waters by 2027. And I just want you to keep hold of that one for a minute, because I'll come back to it. Okay, so the 7 A's, these are the principles that we might think about judging, I suppose, targets in the Act. The first accusation that was made about all of these targets when they came out was that the government was somehow abandoning lots of our existing targets. You know, we've seen there are targets on the tree, but actually there's lots of targets that are elsewhere in the box. And people were confused by that. They thought, well, okay, here's all these new targets. What about the other ones? So I think that was something that government had to kind of correct as a misimpression. I think my big issue with the Act is that it gives the impression that all the targets are here, you know, and if we might want an Act which contains all of our targets, but actually that's probably slightly unrealistic. So yeah, there's definitely an abundance of targets and they're not all on the tree. I'm just going to motor through these very quickly and then finish. Accountability is another key aspect. We've heard a lot about the OEP, which is a key part of that accountability, which you can see on the slide there. They have a number of relevant duties in relation to the targets and have just come out with that very impressive report that judges the government on how far and how well it's achieving the targets. We can look at ambition. A lot of the targets when they came out in the 2021 Act were criticised for not being ambitious enough. And I think the other thing to draw in mind, and this again picks up on the water framework point, is that targets are national targets and they basically look at a national average. But with a lot of our environments, so much of the important stuff is actually very local, and particularly with water quality, you know, it really matters that targets or objectives are met locally. And so a national target isn't necessarily going to tell you that. And finally, and this is the last slide, I think we need targets to be adaptive. And that's, I suppose, runs counter to what I was saying a little bit a minute ago, that maybe we want an Act which has all the targets in one place. I don't think that's ever going to work because we're always going to have new targets. Targets are always going to be changing, but we do need targets to be able to adapt. And you know, there is facility in the Act to make sure that the targets are adaptive in that way. And I think the OEP keeps government on its toes to make sure that those targets are adapted. Great, so I'll finish there. Thank you.
We have taken too much time to get such wonderful speakers, but also because it took a bit of time to get in the room. Can I steal 5 minutes from the next one? Let's just take a couple of questions, because that was such a rich offering, but it really will only be a couple. Stephen, if you could introduce yourself, and I will, for the benefit of the online audience, repeat the question.
I'm Stephen Hoffman, and I'd like to ask a question about something which Professor Hilson mentioned only about a minute ago. And I wrote down what he said. He said that the targets are national targets, but they need to be met locally. And it occurred to me that this is a very central problem at the moment in environmental law, that Parliament and policymakers are setting targets all over the place. But generally speaking, they do need to be met locally by these 60 or 70 million people in the country at large. And don't we have a serious problem in the mismatch between the way in which obligations are framed on the one hand and the practical methods of meeting them on the other?
Okay, thank you. Stephen Hockman's question was about the fact that we have a significant number of targets set nationally, and do we have a bit of a problem about the practical challenges in delivering them locally? It sounds like you're talking about behaviour change as well as maybe local forms of government. Is that realistic? Is there a mismatch between those national targets where there's a bit of hyperactivity around reducing them and whether there are practical means to deliver them? It's a good question. Chris, did you have any thoughts, or any panel members? Oh, Ruth would like to say something. Chris, do you want to go first?
Yeah, I think the Pickering case, which is currently on appeal, is going to be critical to this. Actually, I mean, I'm sorry to place so much emphasis on that one case, but I think it really will force government to think about how this needs to be done, because you cannot achieve national targets unless there is attention paid on how you deliver them locally, including in that case with river basin management plans, and proper objectives set locally as well. And I think if you don't have that kind of level of detail, then environmental law just doesn't work. So yeah, I think that case will be incredibly important for sorting some of this out.
Great question. I totally agree with you and agree with what Chris has said. Two extra points. Practically, how does the government kind of move forward given the challenge you've set? If the environmental improvement plan, when it's revised, doesn't have a proper delivery plan underneath it with local elements, I think we're going to be asking the same question this time next year in 5 years. This is a theory rather than an answer, but I wonder whether the forthcoming devolution bill that the government is bringing forward, which will change the local delivery landscape across England potentially, maybe in ways that are unhelpful to what we're talking about, but maybe in ways where there might be opportunities created. Let's see.
Yeah, just a quick one from me. Of course, there are always these local delivery aspects of meeting any target, but the big levers are with government. The big levers are with them. The Water Commission, for example, and the legislation that might flow from that, and the investment that will come in because of it, or the new environmental improvement plan and the quality of the delivery plans that flow from that, or indeed the further rollout and adaptation of the ELMS scheme. These are massive levers in the hands of government, and they certainly need to be pulled. Thank you.
Any other burning question? Oh, okay. I'm going to take the one at the back. Sorry, I think you've got him just first. With your name and...
Ted Heisinger, I was just wondering, there's lots here about rules that should be abided by, or the frameworks that new targets should abide by, but there's very little on state capacity itself, on funding for regulators, on funding for DEFRA to implement some of this. So I just like to
probe that issue.
To comment on that aspect.
Ted Heisinger. Heisinger, sorry. So question about, can the panel focus a little bit more on state capacity and resource in addressing some of the challenges I think that have been highlighted? That did come across a little bit in some of the talks, but if that, I'd like to elaborate on that point.
I can start very briefly. So two thoughts. One, very soon we're going to have a government spending review, so we'll know how the government is going to allocate its resources across its entire landscape. How it funds regulatory bodies will be really kind of critical, so watch this space. Secondly, within DEFRA, maybe Becky will say something about this in the next panel, but there is a review being undertaken of its regulatory landscape. Once that review has worked itself through, that might also point to the need for greater capacity, skill sharing, that kind of thing.
Thank you. So I would just say I'm sure that Steve Reid, our Secretary of State, is banging on the door of Treasury, trying to make very plain the urgent need for continued investment in ELM schemes and elsewhere as well. But we mustn't forget that I think there are 25,000 people in the DEFRA wider group. Let's use those to best effect. That's a lot of public money that is available. We argue very strongly that government's plans for the environment need to be prioritised. We have always said that. This is a 25-year environmental improvement plan. Now it needs to do some upfront catch-up stuff, you know, that we identify, of course it does. And it must make plain government's priorities and make sure that the right things happen at the right time. And there is, you know, look at the whole timescale of the plan. Not everything has to be done in the first year, but some of those pressing targets, the ones that are most immediate, mostly relating to nature, they do need the focus on it. So I'm a bit of a cynic actually when it comes to we always need more money. You know, more money is always welcome. You know, I'd like twice as much, and I could probably do twice as much, but 10 times as much, I wouldn't be doing 10 times the stuff. It's not just about the money. It is about how we use it, how we prioritise, how we lead, how we make very clear what is not optional and what must be done by when. And getting that right and commonly understood would take us a long way, in my view. Thank you.
Chris? A last comment from Chris? No?
No. I was once told that targets are important in government because that actually brings the money behind them. I think that's possibly a little bit optimistic because there are so many targets that we can identify here, and they all seem important to us. But as Dame Glenys says, I think it's really important to work out which ones we think are the apex or priority targets and make sure that those are the ones that get appropriately funded. And dare I say, it's a little bit of a dirty word, but you might want to think about the use of cost-benefit analysis to try and work out, you know, which ones are going to deliver the best bang for our buck environmentally, you know.
Thank you very much to the panel. We're going to have a switch.
Okay, let's move on. We're running behind time. It's my pleasure to welcome you to the second part of this session on the day when Rachel Reeves has told us that the economy trumps environment. So let's see where that takes us. This is a fantastic session. I really enjoyed this because although Parliament has set up the OEP to run a periodic statutory review of what's happening in the world of the environment, UCL didn't think that was enough and thought they needed to set up their own stakeholder community-based version. So here we are, version 3. No doubt will be version 4 in a few years' time. Even better, because last time, I'm going to introduce 3 people very briefly. Becky is here from DEFRA to tell us what the new government is thinking about. Richard Broadbent from Freeth is going to tell us about post-Brexit developments in habitats regulations. And UCL's own Maria Lee is going to tell us about her thesis about how the planning system is shifting from being political to being technocratic. Becky, I'm particularly pleased to welcome, because last time she was here, no spoiler alert, last time she reassured us that the DEFRA officials were not going to let the whole of environmental law go over the ruler cliff, and she was right. So I'm hoping we're going to get similar reassurances this time. I will leave you to introduce yourselves because we're running out of time, but I think you all know who you are, so I don't need to spend too long on that. So, Becky, what is the current government thinking about environmental law? You can do it from there, or you can go and stand up there if you prefer.
Shall I do it from here?
By all means, if you haven't got slides. So.
I haven't got slides.
No, so do it from here.
Fab. Thank you so much for that introduction, and no pressure that last time I was able to give some reassurance. Hopefully this time I can do a little bit of that as well. It's lovely to see everybody. When I was thinking about what I was going to say today, I did think back to the session that we had the last time and just how different the landscape for regulation seemed to be at that point, I suppose certainly from government to sort of where it is today, where we were sort of thinking about retained EU law. We didn't really know quite what the Act, I think, would involve, and there was so much uncertainty around the stripping away of environmental regulation and a huge amount of concern around that. And it does feel really different today. Today it feels like we are actually in a much better place. We still have, we've sort of come out the other side of the retained EU law space, and we've still got, you know, all of the regulations that were so important when we discussed those last time. So that's really, really positive. I think it is a really important time at the moment to just sort of take stock and reflect on where we are. And I suppose part of what I'm going to talk about is the way that the government is trying to take stock of where we are on regulation more broadly. And I'll give a little bit of a sense of that, I hope. So I think the government really does see regulation as an absolutely key tool. And I think there's a genuine belief that if it's got right, it doesn't have to be environment versus growth. It can be both at the same time, and that is what we absolutely want to achieve. So I think the spirit of the reviews that we are undertaking at the moment is all under that umbrella of we want to achieve both of these objectives. We do not want to see the one thing pitted against the other. We want to try and create a system where we can both unlock growth and protect the environment. But that is obviously a lot easier for me to say than it is to do in practice. And so I think that's partly why we've commissioned a couple of reviews, and I'll just touch on those and what they're looking to do, and then I'll just give a bit of a sense of how that fits within the wider government landscape. So DEFRA has already commissioned in particular 2 independent reviews that you've probably heard something about. So they've commissioned Dan Corrie to have a look at the whole of the regulatory landscape. And Dan has actually got a really, really strong background in regulation. So when he was formerly sort of head of the number 10 policy unit under the last Labour government, he did a huge amount of work in setting up the sort of regulatory landscape during that period of time, so setting up some of the big regulators. But he's also been really involved the last 13 years in supporting the voluntary sector, working with charities. So he's got sort of a really good understanding of both the sort of regulatory landscape, but also I think of some of the challenges, some of the ways in which sort of things can be delivered. And he's undertaken sort of quite a wide-ranging review of the whole of DEFRA's regulation, so a massive, massive undertaking in a really, really short space of time. But the aim is for that review to report to our ministers during this month, so within the next sort of couple of weeks. And the way that he's approached that is really through a huge programme of engagement involving, I know, a number of you in the room, and I want to say to everyone who's here who has contributed, just a huge thanks. I think we've had 70 meetings, maybe more, with experts. That's included our own regulators, obviously, academics, think tanks, industry experts, and our sort of customers. So we've done quite a lot of work with customers in this space as well. And he's also been out on some really, really useful sort of visits to actually see in practice what's happening on the ground in terms of regulatory practice and how that's having an impact on the environment. And I think some of the themes that are going to come out in terms of the review are around not wanting to kind of rip up or do a bonfire of regulation. I don't think that's the sort of space that we're in. I think Dan wants to think about the whole system and how does the system work? Are there changes that we can make to make that system more effective? There are things that we've looked at around where you could use regulation actually in a more powerful way to stimulate investment, which is something that Glenys and others on the previous panel talked about. So are there actually things that regulation could do that are positive? Could it be used, for example, to stimulate more nature-based solutions, more green finance, other forms of investment in the environment? But he also has really wanted to think about how our customers experience DEFRA's regulation. And that has led to a lot of reflection on the complexity of the landscape, which is something that Professor Hilson also touched on in terms of the number of targets, the number of regulatory frameworks. In some areas, they're very, very complex, they're duplicative, they've grown up over time. And I think one of the challenges that has sort of come out is whether some of the people that we're regulating really understand what they're supposed to be complying with. So there is a genuine struggle around, do you actually understand the standards and the rules that apply to you? And obviously if you don't, it's very, very difficult to comply. And then it's very, very difficult to have an effective process of regulation, because obviously the whole idea of regulation is that you rely on a certain number of people wanting to do the right thing and being able to do the right thing, so you can then focus your attention on those who are deliberately not doing the right thing and try and correct that. And at the moment, it feels like that balance is maybe not quite right. So that's one of the things that we're really looking at as part of this work. And then there's also obviously the review that again was mentioned by the previous panel that John Cunliffe is leading on water. And that is, the aim of that review is to sort of reset the water sector. Again, that's going to review the whole of the regulatory framework as it applies to the water system. It's going to really think about strategic planning in terms of water resources. And it really wants to try and recreate an environment where regulation can be effective and where public trust can be restored. And I think trust in regulation and regulators is a theme that's kind of coming through quite strongly in both of these reviews. So I suppose, what is the hope on the back of those reviews? So the hope is that that will set a path towards change in the regulatory landscape for the next few years. And I think that the hope is that that will all complement other parts of government that are also looking at regulation. So I think everyone will be aware that the Chancellor is really interested in regulation. She's held some roundtables in the last week or so to talk to regulators about their ideas about how they can work differently, how they can stimulate growth. We are hoping that all of the work that's going on there can be influenced by the work of the reviews that DEFRA's undertaking, so that we don't get into a situation where, so we can be really complementary in how those things are moving together. I think as well as that, sorry David, I'll be very brief. So I think as well as the reviews, it's really important we just don't lose sight on some of the fundamentals. And I hope, obviously Dame Glenys will sort of hopefully keep us to this as well. But we obviously haven't always been fantastic at doing some of the absolutely core elements of the existing regulatory framework, like things like our post-implementation reviews and the other things that are fundamental to making sure that you've got a good regulatory system. And the department is really committed now to trying to sort of rectify that. I think we published a large number of reviews last month, and we really are trying to kind of get back on track on really understanding whether our regulations themselves are effective, and then taking the action that we need to on that. I'll stop there, David.
Thank you very much. Richard. Is your microphone working?
I hope it is. Is that working?
Okay.
Well, it's a pleasure to be here. I'm Richard Broadbent. I'm a director at a law firm called Freeths. But prior to that, I worked in Natural England. I was head of legal there.
Try that one. That's a bit better.
This one's better.
There we go. That's better. Brilliant. Okay. So it's a pleasure to be here. I'm Richard Broadbent. I'm a director at a firm called Freeths. I do nature conservation law, and prior to that, I was head of legal at Natural England. I worked there for about 11 years. So I'm going to talk to you mostly about nature conservation law and my take on that. And thank you so much for making your way to the room. I felt like I passed a Balrog on my way down here. So yeah, and there's so many people I appreciate and respect in this audience. So it's great to be here. Okay, quote. The old EU directives, such as the Habitats Directive, had good intentions, but their interpretation has often led to high levels of legal uncertainty, which can be corrosive to good governance. That's a quote from the then Secretary of State, George Eustace, in the Nature Recovery Green Paper, which was published in March 2022 in the wake of Brexit. And clearly there was a strong intention post-Brexit to amend the Habitats Regulations. The Habitats Regulations is the piece of law in this country which transposes the requirements of the Habitats Directive and the Birds Directive. It's a piece of legislation I work with the most. And there was a bevy of powers put into legislation to enable this to happen. So in the Environment Act, powers were put into sections 112 and 113 to allow for amendments to the Habitats Regulations to be made. Amendments to Regulation 9, which requires competent authorities to have regard to the objectives of those directives, and also provisions which allow for the amendment of the assessment of plans and projects that sort of meet of the Habitats Directive. So powers in the Environment Act on that. There are also powers in the Levelling Up and Regeneration Act with the introduction of the environmental outcome reports to allow for quite widespread amendments to the Habitats Regulations. There were powers in the Energy Act 2023 to allow for strategic compensation for relevant offshore wind development, to allow for a strategic provision for that, but that also gave ministers quite broad powers to amend the habitat regulations. And finally, as we've heard already this evening, powers in the retained EU Law Act. There's still powers in there which would allow for quite widespread amendments to these retained EU laws. And there's backstops, for example, in the Environment Act on the use of those powers, but no backstops in the Rule Act. So, if this was a cartoon, all the knives would be out, all the daggers out, pointing at the habitats regulations, but they have not yet been used, that it's harder to wield these powers in practice. And why is that? Well, there are some reasons for that. A lot of this legislation is derived from international law, and we are still signatories to that international law. So I'll give you a few examples in my area. So the Berne Convention, for example, which protects habitats and species, Article 9 of that contains legal tests for the protection of habitats and species, which is replicated in the habitats regulations. So formulas which we're familiar with from the habitats regulations, such as there being no other satisfactory solution, or exceptions will not be detrimental to the survival of the population concerned, or overriding public interest. Formulations of that are in the habitats regulations. We're also a signatory to the Ramsar Convention. Indeed, we have most of the Ramsar sites in the world. We have a disproportionately high number of them in this country. And provisions like Article 4 of that require compensation for harm to those sites, and the Habitats Regulations provides for that. And of course, we've got the UK-EU Trade and Cooperation Agreement we've heard about already tonight, which says we must have a level playing field and non-regression obligations to prevent significant divergences. So those powers haven't been used, but what have we seen? Well, what we've seen is a move towards a strategic approach. And today, on the front page of the Times, there's an article there about the government stripping Quangos of their powers to delay development. And this sort of shift to a strategic approach. So what does that mean in practice? What are we looking at here? And we have a glimpse of that with the powers that exist in the Energy Act. So just before Christmas, we had the publication of the government's planning reform working paper on development and nature recovery. So that's a working paper. It's not even a consultation. It's not saying a green paper. And we're invited to give responses to that. And in that working paper, the government proposes a new approach to development and nature recovery, replacing a status quo which it calls unacceptable. In essence, the government will use funding levied from developers, paid into a nature restoration fund, to deliver environmental improvements at scale, which will have the greatest impact. And this will be done by a delivery body, appointed by the Secretary of State, acting in accordance with delivery plans, signed off by the Secretary of State. And the government says this will be a win-win situation by shifting more responsibility onto the state to deliver. So what does that mean for practitioners like me? Well, in some cases where the impacts of development are known and very similar, and there's lots of developers with similar impacts, and there are settled ways of assessing that with literal calculators to do that, and there are settled ways of addressing those impacts through an agreed suite of measures, then yeah, I can see how this would be quite useful. And diffuse pollution is clearly what they're going at here, and trying to come up with a strategic solution to unlock development through having a joined-up approach to the way that we do mitigation through nutrient neutrality. So fine, I can see that would happen. And you could see the benefits of this, because at a landscape scale, for example, you could do things like push farming back from the river's edge, so that would reduce the amount of runoff that you get into rivers. That would drastically reduce diffuse pollution effects. Or you could incentivize farmers to improve the biodiversity, the ecology of their soil, so it could hold water better, pulling nutrients into it instead of just running off straight into the rivers and causing problems. So you can see how those things could be done at a strategic level, and that's good. It's not necessary, and it could be easier as well. The developers just let the assessment be done by someone else. They just pay into a fund, and that's fine. Now, it wouldn't necessarily be quicker to do this, because, well, if you don't want to reduce environmental standards, then you need to have these measures in place from the get-go. And if there's a time lag there and you're not in control of that time lag, then that could be an issue for developers. But what does this mean for nature conservation law? And that's what I really want to talk with you about. Well, this is a significant shift in that burden of responsibility in the way that nature conservation regulation operates. Now, a thriving, healthy natural environment is a legitimate concern for a government, indeed all of us, as this is necessary for a collective common good. Government does have a role in ensuring that the social conditions are available which allow people, groups, or individuals to reach their fulfillment of the common good in this way. And in times of crisis, understandably, it's legitimate for the government to step in and correct serious imbalances which cause injustice or inequality. And that's fine. We saw that, for example, the government's response to COVID. Time of crisis, the government steps in and uses its power to try and deal with things. However, like COVID, such government intervention really ought to be short-lived. And why is that? Well, that's because it risks infringing that principle which our European cousins refer to as subsidiarity. And the principle of subsidiarity protects people from abuses by government. And it recognizes that everyone, families, groups, they all have something original to offer to the wider community. And without a proper regard to democracy, that can lead to a loss of energy and diminish our sense of personal responsibility, initiative, and ability to solve problems. And for that reason, it's wrong to overstep that mark. So, what do I think should happen here? Well, there's two crises, and we've seen these crises coming: housing crisis and biodiversity crisis. It's a shame that we allowed this to happen. And as G.K. Chesterton said, he's alumni of UCL, it's terrible to contemplate just how few politicians are hanged. These are crises that we saw coming, and we've allowed this to happen. But if the government steps in and takes control of that, fine, but do not linger there. And there are three reasons why. One is it can cause a movement to a technocratic approach, where you remove that democratic instinct. And that's something that Maria will talk about next. Secondly, what's the point of environmental law? The point of environmental law is to institutionalize stewardship obligations towards the natural environment. That's what it's there to do. And if you sequester that to the state to do that for you, well, you're losing something there. You're losing the power of the law to be a teacher and to affect our behaviors and our norms. And that's a really important thing. And you have to think about the consequences of that. And then thirdly, well, look, if you're going to let the state take over, then there's a tendency towards being bureaucratic in that and the costs associated with that. And that's fine because the developers will pay into a fund, but they'll pass that cost on to the first-time buyers of homes. And it's going to be young people and families who are going to pay for the cost of that. And that's, unconscionable. So, to conclude, as I'm being rushed, we've not seen these powers yet move to amend the habitats regulations. And if we get the cost of this wrong, we may see those powers being used. I'm not saying any of these problems are insurmountable. That they're not. They can be addressed, but it needs real careful thought to do that. Thank you.
Okay, so planning is a wonderful thing. It's a space in which we collaborate to articulate and implement our vision for a place. It's fundamentally democratic. It constitutes our democracy in the sense that we make democracy as we go about governing our place. And it's also embedded in our representative and our participatory democratic institutions. If we didn't have planning, we would have to make it up, but it doesn't feel like that at the moment. Planning is under-resourced, it is unloved, and as the TCPA's Rainsford Review put it a few years ago, mainstream politics has vilified planning for decades. It's really disappointing that the political rhetoric hasn't improved recently. And I'll suggest today that the democratic potential, the importance of planning to people and to place, is really in danger of being overlooked. And for all that planning is vilified, it is seen as very powerful. Apparently, it is a barrier to economic growth, it is the reason for our housing crisis, and it is more part of the problem than the solution to climate change. All of that is at the very least contestable, but perhaps for another day. But these are genuinely social concerns, they're genuinely vital, especially if we really are going to have Angela Rayner's social housing revolution. So it's not that there's nothing there to worry about. Planning is subject to perpetual reform. The current changes, there's a lot we don't know, but the current changes include significant policy movement, a promised new planning and infrastructure bill, and what we are calling English devolution. I don't know if that's the right name, but what we're calling English devolution is on its way.
This agenda is dense, complicated, nuanced, and my high-level, overarching, probably even overreaching comments are necessarily contestable. That's fine. Okay, so economic growth and housing pervade the documents and the speeches. A bit of climate, not much. There is almost no discussion of people as agents. Local people, local democracy, local decision making is mentioned occasionally, but there's no work being done alongside those mentions. There's no real institutional thinking about how we include people and why it hasn't worked. Now, democracy isn't on or off, so there's no single right answer to how much democracy. But we live in a context now of really profound economic inequality, dangerous political division. Planning mustn't make things worse, and it should make things better, and it could. But it's hard to see how we do planning in a just and effective way with less inclusive approaches to decision making. So there's always been a tension, this is not new, there has always been a tension between the technocratic and the democratic in planning. The technocratic is being reinforced right now in the sense of a preference for presenting everything as if it were a technical problem with a technical solution, rather than grappling with the social, economic, political nature of our challenges. Taking housing, the obscure centralised definition of national housing need and then its local or regional allocation through nationally defined standard methods, that's not new. And it has for many years been very difficult for a local planning authority not meeting its housing targets to say no to speculative housing applications, even if there's land allocated in the plan. It's really hard to say no. Even more obscure than housing need is the viability of development. And that's a key issue in whether public goods will be developed. Just because the development is unviable, and we hear it all the time, it's unviable, so we get rid of the environmental measures, we get rid of affordable housing, we get rid of social infrastructure. It doesn't mean no one's making any money out of it. So embedded in that viability assessment, we get professional fees. And think about how outgunned environmental activists and indeed local planning authorities are professionally in these debates. You get a return for developers, you get a premium for landowners, all embedded in viability. These are things that I think ordinary people, like me, might legitimately have a view on. This narrowly technical debate isn't new. The level of building is to increase, though, and some of the countervailing values that sort of got at that technical debate are being removed. Most obviously, the green belt protections are being reduced. Also, habitat, species, environmental impact assessment. On viability, we might note the incentives implicit in having very hard targets for building houses, but no target at all for social housing. And that will come out in viability assessments. We're also seeing an emphasis on the plan, not new. The plan-led system is a long-standing elusive goal. It is a good thing, it is not a bad thing. Three things. First of all, as with consenting, democratic plan makers have their hands tied, most obviously on housing numbers. Secondly, the local is getting bigger, so the planned abolition of two-tier councils, plus the coverage of strategic authorities across the country, plan making gets bigger. Moving engagement, participation, democracy to the plan stage, this is not a bad thing if it means that we get engaged in that vision for a place earlier. It's a good thing. Strategic planning is a good thing if we get engaged earlier. But my third point is that it's really well recognised that engagement, legitimacy, trust is harder the bigger the scale. Okay, it's much easier to engage people at a local level, much harder the bigger the scale. And what I don't see are any fresh resources or any fresh thinking to address that sort of geographical and constitutional challenge of scale. Moreover, I think without special effort, if we just do nothing about it, in these larger polities, the neglected places and neglected communities may well find it even harder to be heard. Okay, so just to finish, the intensification of changes pursued over many years is only not shocking because of the vilification of the past 40 years. We're starting at the end of an argument, and I'm quite aware that I'm on the losing side of that argument. Perhaps observing the further erosion of democracy is a waste of time. But you can get rid of democracy, you can't get rid of the politics. Costs and benefits are distributed, winners and losers are created, particular values and ways of seeing the world are reinforced through planning. And if the democracy in planning is knowingly being weakened, who is going to do the politics? What do we think is going to happen here? Now, lots of students in the room this year and previous years, we often talk about the difficulty of optimism in this area in a time of crisis. So I'm going to end where I started, which is to remind us all that planning could be, should be, sometimes even is, a really properly wonderful thing.
Thank you very much, Maria. We've got time for 2 quick questions and quick answers, if anybody's got down the front here. Hello.
Hi, I'm one of the students here at UCL. Thank you everyone for your very engaging presentations. I think Maria, you both mentioned public trust, so that stood out to me. What are your ideas on increasing public trust through reviews, like you mentioned, through planning?
Thank you. So the question is, how can we restore public trust through the kinds of processes that are going on?
So I'll just give a couple of ideas. So I think there's something about how we monitor the impact of the regulations that we're trying to enforce and how transparent that is to people, so to normal people. So, you know, can you log into an Environment Agency website and see what's actually happening on water quality near you? Can you do that in a way that you can see it over time changing by the actions that regulators are taking? That's really difficult to do because it does need a much greater sort of level of investment in modern systems, digitisation. Even the use of AI can be really powerful, I think, in that sort of space. So that's one way, I think, that the public can get a much clearer view of what's actually happening and then feel more empowered to hold people to account.
I think one of the difficulties in planning, I think monitoring is key across the board, actually. But one of the difficulties in planning is that people have been led up to the top of the hill and then just abandoned there. So, you know, please be consulted, talk to us, tell us what you think. And then it turns out that the democratic decision makers have no freedom of action. And doing stuff to people is very likely to erode trust. So I actually think there needs to be some really serious thinking about why we think this has gone wrong. Because the answer to it having gone wrong, to participation being problematic, to our democratic processes being problematic, the answer can't be just to pretend it's not happening and to pretend this is a technical question. So I think somebody alongside all these regulatory reviews needs to think quite hard about how we might better include and engage people in the decisions that need to be taken.
Thank you. There's a question from over here. Any questions from over here? No, back over here. Wow, you've silenced everybody. That's fantastic. So, well, I was left reassured by Becky, slightly anxious by Richard, and thoughtful by Maria. So I'm going to share the thoughts. Everybody, thank you very much. Before I let you go, I just want to share a thought with you about a process which is in government but not part of Becky's department, you'd be reassured. Some of you will have seen towards the end of the last government they conducted a review process into development consent orders with the proposition that judicial reviews were inappropriately holding up development. And there was a report and all the rest of it. Anyway, the new government inherited that, to be fair to them, and they produced a consultation, and the consultation is now closed, and we're waiting to see the results of that. And we hope that they don't go forward with what are effectively inherited proposals to make it harder to hold government to account for development consent orders. So to remind you, these are the biggest proposals for planning. There have only been 134 of them across the whole thing. That tells you how big these are. They're the biggest road schemes, airports, oil platforms, and so on. What was stark, I thought, about the consultation, I just want to leave you with this thought, was that the proposition in the consultation paper was that only 4 of these schemes have been found unlawful. Now, these are the biggest multi-billion pound, if not government, normally government-sponsored, decisions by ministers. Only 4, they said. I find that a shocking proposition. The fact that any of them were found unlawful, I find to be quite surprising. So I really hope, and I share this with you now, that not Becky's department, different department, takes the view that actually any government decisions around DCOs found unlawful is unacceptable, and that judicial review remains one of the key processes, along with OEP and others, that keeps that in check. Anyway, with that thought, I will look forward to the next UCL periodic review of environmental law, no doubt in a couple of years' time, and invite you to make your way upstairs for some drinks. Thanks very much, everybody.